What is rule of law? What is Lex Rex, which means law is king? When I was explaining the evolution of administrative law, we looked at it in three stages. Since the concept of rule of law is one of the basic principles of administrative law, the development of this principle also follows the same three stages. When many countries were police states, when democratic states started emerging, and the rise of social welfare states after the Second World War. In police states, the king was the law because the king decided what was the law and how it would be implemented. At the same time, the king and the state were above the law. That is, they could not be held accountable for any of their own actions. So, Rex Lex simply means the king is the law. With the rise of the democratic states, where the people were directly or indirectly electing their leaders, the powers of the kings and the queens started to diminish. The law was seen as a guard for the common citizens against the misuse of power by the state. The law guaranteed the freedoms of the general public. While the king or the state were not completely above the law, the state was still immune to a very high degree. There were still a lot of things that the state could do without being held accountable. For example, the king or the state could give special benefits or privileges to chosen persons, and the common citizens could not do anything about it. In this stage, the concept of rule of law was evolving, but it had not become established. In social welfare states, the concept of rule of law became one of the fundamental rules of democracies. From Rex Lex, the society had moved to Lex Rex, that is, from the king is the law to the law is the king. Law became an instrument not only to secure the liberty and the rights of the people, but also to achieve social justice and equality. One of the basic foundations of the concept of rule of law is that everyone is to be treated equally by the state and by the law. And under the rule of law, the law is supreme. So even the state is subject to the rule of law, with perhaps a few specific exemptions like when the security or the integrity of the country itself is at stake. Let me also add here that this explanation is a highly simplified version, because we can always argue that the concept or the idea of Lex Rex actually dates back to the 12th century, falling somewhere here. But while the idea may be from here, it became one of the fundamental principles of law here. Rule of law is a simple but important principle of administrative law that says that every individual, including those in positions of authority, is subject to the law and no one is above it. In the Indian context, the rule of law is embedded in the Constitution itself, ensuring that governmental actions are not arbitrary, but are based on established laws and standards. For example, the right to information, which enables citizens to obtain information from public authorities, also makes the administration more transparent. If there are large projects like factories, dams, mines, etc., before granting an industrial license or environmental clearance or any other significant permissions, the administrative bodies must follow some statutory guidelines. They must seek public comments if required and must provide reasons for their decisions. They cannot just simply approve or reject arbitrarily without providing reasons for their actions or decisions. When it comes to public procurement through government tenders and contracts, they also must follow transparent process, published criteria, and standardized evaluation procedures. This is supposed to avoid favoritism, corruption, and to ensure that the law is king, rather than the decision being taken on the personal whims of the officials. And even when the government implements any reservation policies for any sections of the society, such policies must be based on constitutional provisions and must be within the limits set by the judicial directives. Let us look at the core elements or characteristics of the rule of law. The first one is the supremacy of the Constitution. The Indian Constitution is the supreme law of the land. So, all governmental actions must conform to constitutional principles and cannot violate fundamental rights. The next one is equality before the law. Article 14 of the Indian Constitution guarantees equality before the law and equal protection of laws. So, administrative decisions and state policies must not discriminate arbitrarily between persons. Accountability of administrative actions. Administrative authorities must act within the scope of the powers conferred by the legislation. Actions beyond their authority, which are ultra-vires, can be struck down by the courts. Transparent and reasoned decisions. Here, the doctrine of reasonableness requires every administrative order to be supported by logical and rational grounds. Decisions must be supported by reasons, preventing arbitrariness and ensuring fairness in decision making. These 2 points come under the concept of a speaking order, which I will cover later in this series. A speaking order is a decision or an order that explicitly states the reasons for the decision. And finally, judicial review. As per the Constitution, the Indian judiciary, particularly the High Courts and the Supreme Court, have the power of judicial review over administrative actions. So, citizens can approach the courts to challenge any arbitrary or unlawful administrative actions. These are some of the important cases where the courts upheld or reinforced the principle of rule of law. The A.K. Gopalan versus State of Madras decision in 1950 is noted for being probably the earliest interpretation of fundamental rights. And in this case, the court stressed on the need to follow established procedures. Why is this the earliest? Well, the Constitution itself came into effect from 1950. So, this decision is from the same year. The Maneka Gandhi versus Union of India decision in 1978 expanded the concept of personal liberty under Article 21. Here, the court also introduced the principle that state action must be just, fair and reasonable, reinforcing that arbitrary administrative action is against the rule of law. In the Bachchan Singh versus State of Punjab case, the court affirmed the necessity of reasoned and fair procedure in administrative actions, even in capital punishment cases. In the D.S. Nakara versus Union of India decision, the court struck down discriminatory pension rules for government employees and emphasized on the importance of equality and non-arbitrariness in administrative actions. The Common Cause versus Union of India decision in 1996 highlighted the importance of accountability and transparency in administrative actions, especially in the allocation of public resources. In the I.R. Coelho versus State of Tamil Nadu decision, the court reaffirmed the primacy of fundamental rights and the basic structure of the Constitution, holding that these cannot be abridged, that is, removed or reduced, by administrative actions or legislative actions. The court also reiterated the importance of judicial review over legislative and administrative actions, which is an important aspect of the rule of law.